Hello and welcome to another edition of Civil Discourse Now. I'm Mark Small. I'm an Indianapolis attorney, co-host with Paul Ogden, also another Indianapolis attorney. Hello, Paul. This is January 7th, 2012. We are coming to you from Big Hat Books in Broad Ripple, Indiana. This is where we shoot the show. Paul, explain what the show is about.
Well, Mark, the show Civil Discourse Now is about a civil discussion of local, state, national, and international issues. We're trying to bring to the public forum a discussion where people aren't talking over each other, where we're discussing things perhaps on a more intellectual level. I'm not sure about that from you, Mark, but we are hopefully bringing that to the audience and bringing that to the public, and I think it's something that's long been needed.
Our guests today are Nicolas Martin. He's a longtime libertarian, that's with a small L, devoted serf to his 9-year-old daughter. He's also a funeral photographer. He blogs quite a bit. Jeff Cox, jrcoxlawllc.com, he's been a guest previously on the show. And Jeff, Big Hat Books has books to sell here. What do they have that's pretty good right now?
Absolutely. Big Hat Books is a great independent bookstore, and right now featured at Big Hat Books we have And So It Goes, Kurt Vonnegut, A Life by Charles J. Shields. Charles J. Shields, also the author of Mockingbird, A Portrait of Harper Lee. And so this book is available right here at Big Hat Books. When you want a book, look for the Big Hat. Big Hat Books at the corner of 65th and Cornell, right by the Monon Trail in Broad Ripple.
He's been wanting to do that for a couple of months, so he's finally gotten that out of the way. Today we're going to talk about two areas, two topics. One, the first couple of segments we're going to discuss the propriety, the complexity, the sanity of Citizens United versus Federal Election Commission, handed down by the United States Supreme Court in January 2010. The other decision is a decision that was just handed down a couple of weeks ago, and that was Western Tradition, WTP, partnership versus Attorney General of the state of Montana, where the Montana Supreme Court basically slapped the United States Supreme Court and said that kind of the opposite. To let you know what the decision in Citizens United was, there was a film produced called Hillary. It was about Hillary Clinton. It was released in January 2008. Obviously, Senator Clinton was going into presidential primaries that year to seek nomination of her party, the Democratic Party. Citizens United is a corporation that had funded the production of the film, and they were airing ads, sought to air ads, and sought to do pay-per-view. I mean, I guess people get off on pay-per-view in hotels, but I don't
know. Video on demand.
Video on demand.
I don't know. Do Hillary Clinton and pay-per-view? I don't know that necessarily works.
Well,
I think it was video on demand.
Well, anyways, Citizens United is a nonprofit corporation. Its annual budget was about $12 million. Most of the funds were from donations by individuals, but in addition, it accepted small portions of its funds from nonprofit corporations. It sought to air the commercials. The Federal Election Commission said there were restrictions on what it could do. Specifically, I think they couldn't air the commercials within 30
days of a primary, within 60 days of the general election.
That was part of the McCain-Feingold campaign finance reform law.
And the decision was, it was disposed of at district court with certain stipulations. And one of the stipulations was that the issue that came up before the Supreme Court was not going to be argued.
Which was a challenge of the constitutionality of the statute.
Constitutionality of the statute was not argued at the district court by stipulation of the parties. And so it went up to the U.S. Supreme Court, and the Supreme Court, in a 5-4 decision written by Justice Anthony Kennedy, held that the restrictions, first of all, it held that a corporation is a human being, essentially.
Which was a continuation of previous precedent.
It was a little bit of more of that. It was kind of an expansion. That's what I would say. It also said that the provisions for limitations on the corporate donations to the financing, etc., were unconstitutional, and that the disclosure requirements of the federal statute, that whomever it was donating, those restrictions were not unconstitutional. They passed constitutional muster, or mustard if you'd rather have a different allegory. But that's what Citizens United did. It had the effect, in a lot of the decision has the effect of freeing up corporations a lot more in elections, in campaigns. Now,
independent expenditures, and that's one thing the majority opinion relied on, was that these are not independent expenditures. I guess that is the right term. That this is not money given directly to the campaigns. This is money that they're spending to independently of the campaigns. The campaigns can't control these committees.
And I think that's one big part of Kennedy's decision. He's trying to emphasize that they weren't going to be doing this for the individual candidates. Now, Nicholas, your take on Citizens United, you obviously know why.
It's not very complicated. The government has no authority to control speech in any circumstance except where it is a immediate, proximate threat to life. And there are no circumstances where I would concede that the government has any legitimate authority to regulate individuals or individuals cooperating in associations like corporations in any way. They can spend money on whatever speech they want. They can collaborate. Freedom of association allows them to collaborate in any way they want. And you can either take it as a constitutionalist, and the Constitution is very clear. There are no obvious exceptions to the First Amendment, or you can take it in terms of natural rights, which is that no group of individuals has a moral right to infringe on the freedoms of other individuals, and that's my view, that there is no legitimate reason for government to ever interfere with the peaceful expression, with the peaceful activities, political activities, whether speech or any other form of activity of individuals or groups of individuals.
Okay, Jeff?
Well, a couple of things to point out here. First, I got to disagree with you a little bit. There are situations where the government can restrict freedom of speech. It's been held consistently that commercial speech, for instance, is not entitled to the same protections as political speech, which was at issue in Citizens United. With commercial speech, if you had unfettered right to commercial speech, then we'd all have telemarketers banging down our phones and practically reaching out of them and grabbing us by the throat like we did for so long. That was one instance where the free market, and I know libertarians and a lot of Republicans believe in the free market, but that's where the free market did not work, was with telemarketing, because people didn't want it, but the corporations did, and they kept with that. So there are legitimate boundaries to be put on freedom of speech in terms of commercial speech infringing on personal space. Now,
can I respond to that just slightly? That's a property rights issue. An individual has a right to control his individual space, and nobody has a right to impose himself on your individual space. But that's not a free speech issue per se.
Well, the corporation said it was a free speech issue, but you make a fair point. Now, with respect to Citizens United, there are a couple issues with that. The first, and what I found was the more serious issue.
And excuse me just a second, but the dissent, not the case, there's a lengthy dissent by Justice John Paul Stevens. Go ahead, I'm sorry.
The big problem that with McCain-Feingold before Citizens United, I believe, was the restriction on speech within 30 days of a primary, within 60 days of a general election. Typically, courts have seen that the antidote to bad speech is not restriction of speech, it's more speech. And we need as much speech as possible in the time immediately preceding an election so that we can get more information. Some of it might be bad, but then more speech could counteract that. In fact, a lot of the information we get in campaign commercials is bad, but a lot of it can be counteracted by more speech, not restriction of speech. What McCain-Feingold did and what Citizens United struck down in part was a restriction that said, if you're not a candidate, you can't air these ads. But wait a minute, that's the time immediately before an election is when you need the ads. If you air an ad about the 2012 election in summer 2011, no one's going to pay attention to it. They're going to pay attention right before an election. They're more likely to. And that is what the First Amendment was all about, political speech.
Well, and getting that to that point, as far as independent groups and valuable, accurate information being put into commercials, you have, for example, the Swift Boat commercials. And I think that possibly McCain-Feingold was looking at, it's written by two career politicians who were acting against their self-interest in large part probably, but you have the risk of a corporation coming in and hitting the market with a flood of ads that they're well-financed to do, and nobody's signing off on those ads, and they do it at the last minute.
Well, my response to that is, number one, there was nothing inaccurate about the Swift Boat commercials. Number two, there is problems with corporations maybe spending a lot of money and just buying up all the airtime. But how do you prevent those corporations from doing that and not squeeze out other maybe smaller groups that want to air their commercials as well? You can't throw the baby out with the bathwater. I mean, that would anger a lot of pro-life groups, by the way.
But choice groups, yes.
Yeah, well, pro-life, whatever,
We don't want to go down that road.
Yeah. I'm not touching,
whole other show.
Not touching that one.
That's a whole series of shows.
But corporations, they're not natural persons. That's the definition of a flesh and blood human being under the law. They're not natural persons, but a corporation was set up as a person, not a voting person, but a person for purposes of legal liability, separating it from the human person.
Avoiding liability.
Well, yeah, but it also encourages the startup and the expansion of businesses. That's the purpose behind having the corporation in the first place.
Well, it's important, I think, to also note that corporations are not just profit-making entities. They're also nonprofits. They include the YWCA. They include only, I think, one of the two court cases that we're going to talk about was the entity a profit-making corporation, and that was a profit-making corporation consisting of one person.
As a painting drywall company.
and so it's necessary. The people who are in a frenzy about Citizens United paint the perpetrators of potential evil as large corporations, when in fact they represent a small percentage of all the corporations in America. There are 501c3s, there are churches, there are all sorts of community associations, and they're not necessarily in it for the money.
And the restrictions in McCain-Feingold, they didn't apply to just corporations, they also applied to unions. Which, they've aired ads constantly, and no one's going to, I'm certainly not going to oppose unions airing ads. And I think they should be able to air ads at the time of elections. So I had a major problem with McCain-Feingold from that regard, and it's good that Citizens United stopped that.
We're getting near the end of the first segment, so we'll be right back.